In addition to the case, which was argued by Ms. Stone prior to our recess, I was also provided with State versus Corell, 197 Washington 2nd, 397, a 2021 case by Judge Dixon from this court. I've read that now, and will any further argument. Mr. Kadine, did you have an opportunity to review those?
I did have an opportunity, Your Honor, and I must admit it's a little confusing given our situation here. But it appears to me that I may have erred in adding assault in the third degree and should have added assault in the fourth degree, as what it would appear would be a lesser degree of an intentional assault. So I'm going to propose that be fourth degree.
So when you are making that argument, I think one of the distinctions that I want to hear about is these cases, both cases that were cited, discuss that the charge was assault in the second degree. And therefore, they were looking at the lesser and or inferior degree charge. And it is correct that in, at least specifically in the Corell case, the Supreme Court said that the judge erred when assault in the second degree was charged, and it was charged by strangulation, that the lesser included to that charge would be assault in the fourth degree. In this case, the charge is assault in the first degree, and so I think the differentiation as to what is a lesser included or an inferior charge is, it's the analysis to assault in the first degree, not assault in the second degree. And so that's, if that makes a difference, that is something I would like to hear argument about.
Well, Your Honor, when I read RCW 1061.003, it says upon an indictment or information of an offense, for an offense consisting of different degrees, the jury may find the defendant not guilty of the degree charged in the indictment or information and guilty of any degree inferior thereto. So I don't think that the fact that it's charged first degree limits what the inferior degree crime could be.
Then why wouldn't your assault third degree be the correct
Well,
lesser?
we could include
Under that theory.
Well, I think that one of the issues has to do with the mens rea element. I mean, intentional is an element of first degree, second degree, and fourth degree, but not third degree, because that's a criminal negligence standard. And I note in these cases that were cited, there was no, in Corell, it was a second degree, fourth degree, and third degree was not included. And I think that has to do with the allegation that it was an intentional act as opposed to a negligent act.
So what if I'm looking at Corell and I have it printed on pages. So I'm on page 12 of what was printed for me. I don't know if you have a printed version.
Yeah.
At footnote 50, it says, in sum, we reaffirm that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. The evidence, so I would like to know what evidence, separate and apart from strangulation, has been presented as it relates to the issue of assault, because that goes to the court's consideration.
Well, I mean, obviously there was evidence that he did grab her, and there was evidence in the video that he was touching her and trying to move her from one point to another, which could be considered an assault for these purposes. And regarding the allegations of strangulation, I think again that's something that requires an intent, which I'm not sure has been fully developed in this case.
All right, so just to be clear, you are withdrawing your instructions as it relates to assault in the third degree, and instead are requesting that in addition to the lesser included offense of assault in the second degree, which has been agreed to that there's not an objection to, and from the court's perspective, which is an appropriate instruction, you are requesting that the court give the definition or a elements instruction as a lesser included of assault in the fourth degree.
Correct, as a lesser degree of the initial charge. And I am reading in Brown where it indicates that it would be could potentially be ineffective if I did not ask for that to be done. So I'm asking for that to be done, and obviously that is my request.
All right. And before I hear from Ms. Stone again, Mr. Leary, this instruction does not apply to Mrs. Ali, but do you have anything that you are going to argue to the court? All right, Ms. Stone.
Thank you, Your Honor. Your Honor, I don't read either case essentially to say that once one charge has been done, we just then include every version of the lesser degree offenses. I understand now that counsel has withdrawn the assault third request and is making the assault 4 request. As I looked at Brown and as I looked at Corell, and to be clear, the state provided Corell to all of the parties and the court. The Workman test is the same for each. And looking at the head note 9 at paragraph 48 on Corell, the Supreme Court there, and I would note the Supreme Court did identify that the issue becomes very confusing at times in application, even if the theory itself is relatively simplified. Implicit within Workman's reasoning is the idea when there is affirmative evidence from which the jury can conclude that only the lesser included offense occurred, a lesser offense instruction should be given. The court goes on to say at the end of that paragraph, the test was never intended to require evidence that the greater charged crime was not committed, only that a jury faced with conflicting evidence could conclude that the prosecution had proved only the lesser or inferior crime. The reason that it was an error in Corell to not give the assault 4 instruction is because that in that case there was an argument that one, the defendant had used self-defense or used force for the purpose of self-defense or defense of his property, or that 2, he did not actually strangle because he indicated that the evidence supported an inference that the defendant assaulted but did not strangle his girlfriend, in which case then the assault 4 instruction became appropriate. That does not appear to be the case here, so it's, I guess, confusing to the state why the assault 4 would be appropriate in this case, separate and apart from the assault 2 instruction as it relates to that. I don't think that we just continue to add, and I don't think Workman or Brown or Corell stand for the proposition that we just continue to add lesser offenses each time. So I don't know that assault 4 is appropriate in this case either, based on the facts that we have. but I do believe assault 2 would be appropriate as a lesser included offense. I was looking also at paragraph 45, and just some of these statements that were made from the Workman line of cases. Quote from Gallagher, a defendant may not be convicted of a lesser degree of a crime which is included in a greater degree unless evidence is adduced to sustain a conviction upon the lesser degree. And the quote from Foley, the lesser degree of crime must be submitted to the jury along with the greater degree unless the evidence positively excludes any inference that the lesser crime was committed. It also talks about at paragraph 43 how we've arrived at lesser included offenses under the English common law. So second sentence of that, the common law rule existed to aid the prosecution when the evidence introduced at trial failed to establish an element of the crime charged. So let's say you had theft in the second degree charged, and then at testimony, instead of it being $750, somebody only testified as to $500. In that case, it would be appropriate. And I don't think that that is what we have in this case. So I don't think those are appropriate in this case, assault 3 and assault 4.
All right, well, the assault 3 instructions have been withdrawn and will not be given. So the issue is whether or not an assault in the 4th degree is a lesser degree offense of assault in the 1st degree under the facts of this case. And I think that Corell is the better case in its discussion, and of course it's a published case, than the Brown case, and attempted to be more clear than the Brown case as well.
And Corell is also in 2021, so it's post-Brown, and
Correct.
Brown did rely on that Fernandez, Medina, I believe, language that Corell was trying to clarify as well.
Correct? And the test that the court is to use when giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction is given. And of course, that evidence can come from any source. It doesn't have to be from a defendant testifying, and it can include evidence presented through questions on cross-examination or evidence that is presented by the state. Ms. Stone, as it relates to Mr. Kadine's argument that there is affirmative evidence that would establish assault in the 4th degree, as it relates to what was on the video of Mr. Ali grabbing Fatima and then chasing after her. He had her when she was bent over and is grabbing her in some fashion prior to any evidence of strangulation. And that's what I heard Mr. Kadine was basing his argument that is evidence that would affirmatively establish, I guess, the theory that this was an assault, potentially was an assault in the 4th degree instead of assault in the 1st degree.
Well, I think for that to occur, that would have, for that argument to fit the case law as we have it, it would have to essentially account as 2 separate assaults. As it did in Corell case talked about there essentially being 2 assaults that were occurring instead of 1 ongoing. In this case, it's 1 ongoing assault. So I don't think you can argue that in the process of going to strangle someone, the second that you have grabbed them for the purpose of strangling them, then you are entitled to an assault force instruction as if that is a separate incident from the entirety of the strangulation itself. And so I don't think the argument is consistent with the case law. If counsel is arguing that there is a separate assault, that essentially the first time his client grabs his daughter is the assault for, and that is an appropriate instruction for that incident itself as separate and apart, then I would agree with that assertion in terms of a lesser included offense, but that it did not apply to, in that case, the second grabbing of Fatima and taking her to the ground. I would not agree that the assault for applies based on that set of facts.
Will you state that again?
Yes, Your Honor. So when we are looking at the video, there is the initial contact with Fatima where Mr. Ali is described as aggressively grabbing Fatima, and that is when Isaiah tries to defend Fatima and separate Mr. Ali from Fatima. As you see in the video, Fatima falls down and she's attempting to run away, and Mr. Ali turns and punches while Isaiah is then flying backwards. Mr. Ali goes after Fatima again and puts his hands on Fatima, and then they start to go to them, and that is where the strangulation occurs. If Mr. Kading's argument is that the assault for is appropriate based on that initial grabbing of Fatima where Isaiah, then I think that is appropriate. If that assault for request is based on the moment he puts his hands on his daughter to begin strangling her, that the strangulation has not yet happened, and that assault for is essentially the initial touching and it has not yet developed into strangulation, then I don't think that is appropriate. When we're talking about Corell, the facts in Corell is that there were essentially two separate assaults that occurred, and the court said as it related to this other argument, the court could have determined that these markings on the victim's neck in that case came from something else and not as a result of the incident where the victim described being strangled, that there were essentially two separate. In our case, the state is arguing that this is a common scheme or plan and that there are not two separate incidents. If that is Mr. Kading's argument, then I would agree that he would have a an argument for assault in the fourth degree as a lesser included, if that initial contact is what he is referring to, but not if he is saying it is at the start of essentially the second contact and therefore he's entitled to that, because certainly it goes well beyond that. He doesn't simply touch her and walk away from that. So I don't think assault for in that case is appropriate.
Mr. Kadine?
I have no response, Your Honor. Thank you.
All right. All right. Based upon my reading of State versus Corell, in that case, the Judge Dixon, who's pictured here in our courtroom, was reversed. It was a case where the charge was assault in the second degree. Defense offered an assault in the fourth degree charge. And in an opinion that they said was to help clarify the law, it still continues to be somewhat, not trying to impugn this decision, but it is not, frankly, still completely clear. And I think that that is clear from also what the lawyers argued, that it's not clear necessarily. But the very last paragraph of this decision right before section C, and it is at paragraph 50, it says that in this case, they are reaffirming that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. It's not my job to weigh the evidence or to indicate, as I put together the jury instructions, how the court thinks the evidence has been presented. In this case, I do believe that there has been some evidence that has been presented that affirmatively establishes a theory of assault in the fourth degree. After reading the Corell case, and therefore I will give that as another instruction for a lesser crime. So I want to go back to instruction number 22 on the packet. I am going in the first paragraph.
And I know the court is looking at that now. The state had, only tried to find it last night and could not, that if the court was doing it for, 2 lesser crimes, whether it should be the lesser crimes of assault in the second degree, and then whether it should be an and or an or. I plainly couldn't find that, and I was concerned there might be confusion as to that. So the request of the state was going to be to essentially restate that first paragraph a second time without that first sentence, so that it is very clear. So it would read the first paragraph as it says, the defendant is guilty of the lesser crime of assault in the second degree if, after full and careful deliberation on the charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. So just essentially restating that to not run into that issue of whether an and or an or confuses the jury as to application. And then the third paragraph would remain the same.
Mr. Kadine?
Your Honor, I would not object to that, but I will defer to the court.
All right. That proposal seems appropriate to me, and I think will be the least confusing, will be as clear as possible for the jury as it relates to their analysis. All right. Instruction number 23. That is 23 and 23A. Those are that's the definition of assault in the second degree. And I just want to indicate that I am incorrect in the note that I wrote. The assault in the second degree under WIPIC 35.10 would, except we're using 23A, correct? I apologize. I heard about that before I started the analysis about what the lesser degree charge would be. I believe that there was an agreement to 23A for the definition of assault in the second degree.
Yes, I agree that that would be correct for 23A. If we're going back to 23 regarding strangulation specifically.
But then I don't have to, just a moment, I apologize.
Yes, Your Honor.
I think that instruction 23A addresses both.
Yes.
And so I don't need to get to instruct 23, but I was incorrect about the word intentionally. I indicated in my note on 23 that it was part of the WIPIC, but it is not for the strangulation prong.
Yes, Your Honor. So agreement on 23A, if we're leaving that as it's written.
All right, and then now, Mr. Leary, you can make your argument about the word intentionally.
The other problem is that my client is not charged with recklessly inflicting substantial bodily harm.
That's correct, and it's not in part of the elements instruction either for her. The only thing in the elements instruction for Mrs. Ali is the strangulation.
Right, so I guess if we're giving 23A, do we make it clear that it only applies to Mr. Ali?
No, that's the definition of assault in the second degree. It can happen in one way or it can happen in the other way. And it's the elements instruction that tells the jury what the state has to prove as to each defendant. And it only addresses strangulation as it relates to Mrs. Ali.
So I haven't done a lot of co-defendant trials, so this is kind of why I'm just pausing, because my concern is that the definition of assault in the second degree that includes recklessly inflicts substantial bodily harm, I understand why it's being given as the lesser for the assault in the first degree, but we would never include that. If I'm standing here alone, that language wouldn't be in the definition because it's not charged for my client. And so I understand what the court is saying is to convict my client. I don't know that I'm wrong, but I just have this concern that the definition to the jury for assault in the second degree includes an alternative that my client is not charged with.
The definition defines assault in the second degree, and it indicates that for the purposes of this trial, that assault in the second degree is defined in two different ways. The elements instruction is clear as to how Mrs. Ali is charged. She's not charged, or it's not, the state does not, could not prove that she committed assault in the second degree if she intentionally assaulted another and recklessly inflicted substantial bodily harm, because that's not part of the elements in the elements instruction. But Ms. Stone?
I agree with that, Your Honor. I think the word "or" there is specifically for that purpose, and when we get to the to convict, which is what the jury has to determine the state has proven or disproven beyond a reasonable doubt, that specifically addresses that issue for Mrs. Ali.
And so then if 23 is not given, so the issue as to the word intentionally.
Yes.
So instruction 23 pertains to WIPIC 3510, which does not include the word intentionally.
Correct.
However, if you go to the to convict,
Right?
35.19.01, it does include the word intentionally, and so I requested that those two are consistent, and thus I included the word intentionally assault, even though it's not in the WIPIC as currently formulated.
All right. And that is what, I would indicate that I did understand that when I reviewed your instructions between them. But Ms. Stone,
It feels redundant because that instruction or that word is in assault already that they will have just, I think, been instructed on. I don't know that it particularly matters, but the WIPIC didn't include it, and I assume that that is why, since it is included in the assault definition itself. So it feels redundant.
all right. I am not going to add the word intentionally to 23A. After the "or," it would be, the request is that I put the word intentionally there, intentionally assaults another by strangulation. That is not in the pattern instruction. I don't have to give the pattern instruction, but there's not going to be any confusion. Definition of assault is contained herein, and the elements instruction includes the word intent or intentional there's not going to be any confusion, and we'll use the pattern instruction. Any issue with number 24, Ms. Stone?
No, Your Honor.
Mr. Kadine?
No, Your Honor.
Mr. Leary?
No, Your Honor.
5 and 26, any issues with those, Ms. Stone?
No, Your Honor.
Mr. Kadine?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, on number 27, the proposed instruction from Mr. Kadine. Just a moment here. Let me- Not sure which packet that came in. Well, I think I added the language of the lesser included crime of assault in the second degree. I believe that I added that. I didn't know if that was appropriate or not. I couldn't find the WIPIC that might apply to that.
And I think it's I'm looking at the courts, I think it indicated instruction number 27 state, I don't think the state.
No,
proposed-
it's not. It's
Oh,
not a
okay.
state proposed rule.
27A then, if we're looking at that, essentially instead, I think that is the modified 35, WIPIC 3512 and 3519.01. I don't have, oh, I'm sorry. We talked about it last night. I think the state would be requesting, as it is the alternative means for Mr. Ali. First of all, obviously Fatima's name would be Fatima Ali, and that change would be made. So it'd be 27A using the affirmative, or excuse me, the alternative means, but I think it should be modified in this way instead. Each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about October 18th, 2024, the defendant, comma, it should be then 2, that the defendant intentionally assaulted, sorry, I'm backing up. On or about October 18th, the defendant, on or about October 18th, 2024, semicolon, 1A, intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, semicolon, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either element 1A or 1B have been proved beyond a reasonable doubt, and then the rest of the language is the same as to element 1A and 1B.
Can you print that out?
Yes, Your Honor.
And I want to make sure that I understand the proposed language. And I should have said, can you print that out, please?
I understand.
Okay.
Thank you.
All right, so I'm going to come back to that instruction. All right, number 28 is the elements instruction for assault in the second degree as charged for Mrs. Ali.
Just the name change from the state, Your Honor, or the name spelling out from the state.
So you agree that the word intentionally should be included?
Yes, Your Honor, and it is
Okay.
listed that way in the WIPIC.
Yes, okay. Any issue then with 28, Mr. Kadine,
No, Your Honor.
Mr. Leary?
With the inclusion of intentionally, the change to Fatima Ali, no.
Okay. All right. Next is instruction number 29, which is the definition of unlawful imprisonment, which is WIPIC 39.15, and whether or not the language without legal authority is properly included in this instruction.
No objection from the state, Your Honor, I think that is correct.
All right,
No objection from me either.
so that will be used. Any issues with 30 or 31? Ms. Stone?
No, Your Honor.
Mr. Kadine?
No, Your Honor.
Mr. Leary?
No, Your Honor.
32 and 33 are the elements instructions on unlawful imprisonment for both Mr. Ali and Mrs. Ali. The difference between the state's instruction and each of the defendant's instruction is what I included in here as paragraph 5. And then at the top, it would be whether or not there's 5 or 6 elements. Ms. Stone?
I would leave the state, changing, Fatima Ali's names in, both 32 and, 33. And the principal or accomplice language is, charged in each of those cases as well. And so I think the principal or accomplice language should be included on elements 1.
All right, and any objection to paragraph, or number 5?
One moment, Your Honor, please. I made a note and now I'm trying to understand my note. I guess I was, in terms of element 5, I had a question as to if we know from that the authority when you are restraining your child in the manner in which it was restrained is not legal. So I guess that's my question, what the intent is for defense counsel's version of it. If the argument is going to be that they had the authority to do so in that manner, that they believed they had the authority to do so in that manner, which today would be a jury nullification argument. So I guess my question is, why is element 5 being proposed when that is without legal authority to do so in the manner in which it was done?
Mr. Kadine?
Well, Your Honor, it appears that the knowledge element would be important to include here, since it's obviously an element that regarding parents. If the state argues that the restraint was without legal authority, that's something they have to prove. They should have to prove that the defendant knew also that they did have no legal authority to do that.
Mr. Leary?
So the note on use says that element 5 should be used when facts exist to suggest that the defendant had a good faith belief that he or she has a legal authority. So parents would certainly fall within that category as to having the legal authority and whether or not their actions exceeded their legal authority as parents. And so the knowledge element should be included based on the comment and the note on use in the case law.
So since you're talking about the case law, I looked at Warfield and Johnson related to this issue, and the cases indicate that the knowledge prong, this paragraph or this sentence would only be used where the defendants had a good faith belief that they had legal authority to imprison a person. And in the Warfield case, it was the bounty hunters who picked somebody up on an out-of-state warrant, and they believed that the warrant would have been enforceable here in Washington, but it was only a misdemeanor warrant, and so it wasn't, and they were charged with unlawful imprisonment. They were given, or should have been given, this instruction because they had a good faith belief that in fact they had the ability to take this Warfield, or the person that they had come to Washington State to get, they had the ability to take that person and return them to Arizona. And Johnson, in talking about Warfield, says that Warfield is unique and does not apply to most unlawful imprisonment cases, where there is no indication the defendant believed they actually had the authority to imprison the alleged victim. You wouldn't get number 5. And so is it your argument that because Mr. and Mrs. Ali are parents to Fatima, that they believed that they could restrain her in any fashion?
Not that in any fashion, but that they had the legal authority. So specifically to the acts of my client, she had the legal authority to restrain her runaway daughter in the fashion in which she did. And that the state has to disprove that she was acting with knowledge that the restraint was without legal authority.
All right, Mr. Kadine?
Your Honor, I would concur with that the parents obviously have the right to restrain their children to a certain degree. If the degree is not met, then that's the state's argument regarding why it was unlawful. So I would ask that this be included.
Ms. Stone?
Yes, Your Honor, so even by the information cited by Mr. Leary, there has to be evidence of a good faith belief. Status as parents does not create evidence of a good faith belief. There's been no testimony, there's been no indication of that in this case. Both Mr. Ali and Mrs. Ali strangled their child. That is outside the bounds. And so insofar as at least the state, and maybe it is over interpreting Mr. Leary's argument that his client believed she was able to do so in the manner in which she did. I don't know if that is intended to branch out at closing into some sort of argument of what was the norm in their household, what is a culturally accepted, or something else. Those would be inappropriate. It essentially appears to argue that, well, their ignorance of the law made it okay, and the state can't prove that they didn't have ignorance of the law, and that they decided that was a good faith belief, and there's no standard essentially provided to the jury about what a good faith belief is. So I don't think it's appropriate in this case. The manner in which they restrained her is not legally appropriate, and it is without legal authority. It doesn't prevent defense counsel from making the same argument, but that good faith belief language appears to be provided minimally and rarely at best. And in this case, the jury can make that decision based on the parental discipline instruction. I believe Mr. Leary proposed it as well, Mr. Kadine proposed it. And that provides that information for the jury to decide whether they were acting within or without legal authority versus whether they had a good faith belief to act as they wanted to. So I don't think element 5 applies in this case.
All right. So I think I alluded to this yesterday when I was ruling on Mr. Kadine's motion, I think, to dismiss the unlawful imprisonment charge. This is actually an issue that I have been thinking about as I've gone through the instructions. As I indicated, I read the cases that are cited in the WIPIC, specifically addressing this issue, and that is whether or not included in the elements instruction would be that the defendant knew that such restraint was without legal authority. And I referenced at that time the instruction 21, which is the defense to assault, that the force used was lawful related to discipline of a child, and that instruction specifically talks about that the jury may, but is not required to infer that it is unreasonable to do any of the following acts to correct or restrain a child. And that is because parents have the right, the constitutional right to parent. Kids have no rights, basically, frankly, as it relates to that constitutional right, and parents' right to parent their children how they want to. Now, it can't be abusive, but parents have a great latitude to parent, and kids have no right, they don't have right to good parents. And that's why I say that kids have like no rights. But that's the state of the law, that's the state of our Constitution, and the freedoms that are provided to adults who have children. And I believe it would be inconsistent for me not to include number 5, since I have given the instruction about the discipline instruction. I do think that even though they are different and apply to different things, they are related. And there was no indication that I'm just giving this as an example, that Mr. Ali believed that he had a basis to, I'll stop there. I think these instructions are, that one sentence and that other instruction are related in some fashion. It would be inconsistent for me to not include number 5 because the parents do have the legal authority to restrain children. The issue in this case, of course, is whether or not that was an appropriate restraint. And that's for the jury to address. So I am going to include number 5.
Thank you, Your Honor. I would ask, though, to confirm prior to closing and ask for it to prohibit any argument. That would essentially be a jury nullification argument to the jury at closing, that these two parents in particular, based on their personal beliefs, had a good faith belief that that was okay, as if somehow in violation of the laws, acting within the own scope of what they believe is okay, somehow that it's essentially a moral relativism argument. We can do what we want based on what we think is okay, even if that is inconsistent, and that somehow that then therefore qualifies as a good faith belief. I don't think that is appropriate. I also think that is, as I said, I think it would be a jury nullification argument. I also think it brings in cultural norms that are not appropriate in this case, and we've worked very hard to try and keep those arguments out from the jury so that they are making appropriate decisions.
All right, well, there's been no evidence presented at all related to cultural norms in this family except what Fatima testified to. And so there can't be any argument that infers facts that aren't before the jury. And so I would think that neither Mr. Kadine nor Mr. Leary are intending to make arguments for facts that are not in the record, or a reasonable inference from a fact that is in the record. Is that correct, Mr. Kadine?
Yes, Your Honor.
Mr. Leary?
I certainly do intend to explore the concept of implied bias when establishing and evaluating credibility, which, in terms of how my client is perceived, not her values justify what she did, but in terms of evaluating the evidence and talking about the instruction on implied bias.
All right, well, then I will take up objections during closing argument if the state believes that Mr. Leary is arguing something that is not supported by the facts that are in the record.
Yes, Your Honor, thank you. And I think, was the court including the principal or accomplice language after defendant think I said it, but then we started talking about element 5, and I don't recall where we ended on that.
Thank you. Yeah, I have it. As you said that, I wrote that into these instructions. Mr. Kadine, any objection as it relates to number 32, adding the language as a principal or as an accomplice?
Again, as to the to convict instruction for Mr. Ali, I'm not sure that that's, I mean, is there an allegation that he was somehow involved with Mrs. Ali? Again, I think that this is a situation where she came in after he was no longer involved.
I mean, I don't actually think that that's, I know that that is defense counsel's argument to the jury. I don't think that's consistent with the state's theory of the case. It's also not consistent with the video. She is actually there while he is choking his daughter. So I certainly don't think it hurts, it prejudices the defendant in that case. The state's ability to prove it is the same based on the evidence either way.
All right, Mr. Leary.
I don't believe the court gave accomplice instruction for Mr. Ali on the attempted murder. I don't see how this is different.
And as to Mrs. Ali?
As to instruction 33, based on court's prior ruling on accomplice, I think the language is appropriate.
All right.
Maintaining my theory.
All right. So as to Mr. Ali, as to instruction 32, I am not going to give as principal or as an accomplice. I don't believe that there, even with the inference to, and most favorable to the state as to the evidence that's been presented, that Mr. Ali was an accomplice to anything that Mrs. Ali ultimately did after he was no longer restraining, strangling, whatever word you want to use, Fatima, once he finally released her, once the bystander was able to get him to release her, I don't believe there's any evidence as to any interaction that he had with Mrs. Ali at that point, or until much later. So I won't include the language there, but I am going to include it in 33 as it is appropriate for the reasons I've already articulated. Any issue with 34 or, well, any issue with 34?
No, Your Honor.
All right. So the definition on number 35 is going to be moved. To earlier, as it relates to the inferior matter. So number 36.
No issue on 36, Your Honor.
Except that I need to identify that that applies.
You want to put that as to count 4?
Yes.
Okay, I don't object. However we want to word that, count 4.
So I'm going to syndicate. It is a defense to a charge of assault in the 4th degree as charged in count 4, that the force used was lawful.
And does it need to say charged in count 4 against Mr. Ali, or do we need to, since there's 2 count 4s?
Yes, yeah. It's the same.
Do you believe that it needs to say as charged in count 4 as to Mr. Ali?
I don't think it hurts, Your Honor. I think it's
Okay.
clarifying.
I will add that. The only count for of assault in the fourth degree is to Mr. Ali, but I do want the instructions to be as clear as possible. With that addition, the state's already indicated no issue, and Mr. Kadine, no issue. Anything from you, Mr. Larry, on that one? All
I
right.
do think the state is going to be requesting, though, if the court gives 36, the state is requesting that 1604, first aggressor be provided instruction as well.
Do you have that instruction?
We do have it, Your Honor, we'll print it. We can come back to that then.
All right.
Through the others.
Also, just for the parties' information, as it relates to these instructions that we're looking at right now, I had number 7 as the instruction related to no duty to retreat, and then I have the necessary instruction in 38. I actually would give the necessary instruction. It will be moved up. It'll be before the whether or not there's a duty to retreat if I give both of those instructions. Certainly I'll give the necessary instruction, and that was just my error in not having that be first. Any issue with number 38? Ms. Stone?
No objection to 37 or 38, Your Honor.
Thank you. And then those were your instructions, Mr. Kading, no issue. Mr. Larry?
No issue.
All right. On number 39, Ms. Stone, are you requesting that I continue to use initials?
I am not, Your Honor. I'm asking that you use Mr. Williams' name in that.
Yep, yes. Any objection, Mr. Kading, just to changing that instruction only as to listing the name of the alleged victim instead of initials and removing. Ms. Stone, any issue with 40, 42, 43?
No, Your Honor, none.
Mr. Kading?
No, Your Honor.
Mr. Larry?
I take issue with 41, with 6503. I don't think it actually applies to the facts in this case. I think that pertains to the note on use says do not use this instruction in the usual case. I think it's if there's a partial, like someone breaks a window and sticks a hand in, does that constitute enter for burglary? Here we're talking about her presence on the entire Timberland High School property.
Ms. Stone?
I don't think it hurts to have it. I would agree that following or the insertion of any part of a person's body, we could end it there, period, and the remaining clause would not need to be, or clauses would not need to be included.
All right, I did not look at that, I didn't print that particular instruction as it relates to the WIPIC, and so I want to look at that. So I'm going to have to come back to that one.
So no objection as to 42. And then the court also asking about 43.
That's correct.
Okay, I do have an objection to that. So that is WIPIC 60.05, the inference instruction. Particularly the facts in this case. I think inference, note on use, the WIPIC committee says use caution in giving this instruction, see comment below. They talk about the concern about inference instructions generally. I think there's a particular concern by the defense for Mrs. Ali about the court telling the jury that they can infer that she acted with the intent to commit the crime against the person or property therein, particularly when there's a mixed motive here. The state's allegation is that the burglary charge gives rise from her unlawful entry or remaining at the school with the intent to violate the protection order There's also an equally alternative explanation, which is why she was there, was to see her daughter, recover her daughter, and protect her daughter. And so, obviously, the state can argue to the contrary. I can argue my position, but I think particularly in this case, the inference instruction is improper.
Ms. Stone?
I disagree, Your Honor. I note that counsel makes that argument after modifying the to convict instruction under 46 to try and say that the state essentially must prove and add an additional element of proof to the state, which is not required by law or by statute. The state need not elect any. I think there's a number of arguments as to what crime she could be doing. First of all, she's violating the no contact order. She knows exactly where Isaiah has run. Assaulting Isaiah, she's already described an interaction with Isaiah. Re-assaulting her daughter, re-restraining her daughter.
Also, I printed out and read many of the WIPICs involved in the different charges that are before the court, anticipating different arguments that I thought I would hear. I did not anticipate this argument. I have not read this WIPIC. I also optimistically thought we would conclude instructions before our noon break, and we are not going to, so that'll give me time to look at the WIPIC on both instruction 41 and 43 before I rule on those issues. Number 44.
State agrees we don't need it.
All right, so that's instruction is withdrawn. Any issue with 45, Ms. Stone?
No, Your Honor.
Mr. Kadine?
Nope.
Mr. Leary?
Oh, yeah.
All right. 46 is the elements instruction regarding the burglary in the second degree. The difference, I believe, between the two offered instructions, one from the state, one from Mrs. Ali, was that you have included the specific crime of violation of a court order. Mr. Leary, I'm going to go ahead and let you argue on that.
So I do believe I put in my trial memo that I had a question as to what was the specific underlying crime that my client was alleged to intending to commit. I did have a conversation with Ms. Stone. She indicated to me that it was violation of the protection order. If there are other crimes, then I would make a motion for a bill of particulars as to what crime, and then the question is going to be is whether or not the current jury instructions adequately inform the jury as to what crimes there are. And so I want it to be really, I want to know so that I can articulate and describe why my client, it's two parts: enter or remain unlawfully with the intent to commit a crime. And I think I'm entitled to notice as to what crime the state is alleging my client intended to commit as a part of the burglary. If it's beyond the protection order, I think I want to know what it is, and I want to make sure that the jury is properly instructed as to the crimes that the state is going to use to argue that my client committed burglary.
Ms. Stone?
Your Honor, when we had that conversation, Mr. Leary offered me a number of options. I said, yes, no contact order, a re-assault of Isaiah. With all due respect to Mr. Leary, I would characterize his response to that as poo-pooing some of those options as he disbelieves them, but the state clearly articulated that. We are at the end of trial. I just gave a number of indications of crimes that could be provided. The case law is very clear that that is not an element for the state to prove at trial in a burglary. I have provided now multiple times an indication of arguments the state will make as to what those crimes are. I understand that Mr. Lurie disagrees with those on behalf of his client, but those, plainly, you cannot add elements for the state to prove that are not required by either statute or case law. That is what counsel is intending to do here. It is not appropriate to put that in the to convict instruction because it is not in fact an element. And when we go to argue that to the jury should expressly know that that is not an element. And Mr. Lurie cannot argue that the state has to prove that. The jury does not have to elect which of those it is. The jury has to believe, and that is why the inference language in the prior WIPIC exists in the first place. So it is improper to add that as an element. There is not a bill of particulars at this stage of the case to provide to counsel that I have not already provided in the argument as we have sat here.
So I would just, I'm sure as the court reviews, the court will see note on use. It may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests. It's in the WIPIC 46004. So that's the basis for the request.
What's the, I'm sorry, which WIPIC are you looking at?
So I'm looking at the to convict WIPIC for burglary in the second
Yeah,
degree.
60.04?
Yes, 60.04, which is instruction 46.
Yes. What did you say the language says here?
So note on use?
Yes.
It says, under some circumstances, it may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests.
And then it says burglary in the first degree elements.
It says, see comment, WIPIC 6002, burglary in the first degree elements.
And then when you go down further to comments, under crime against a person or property, ordinarily, the jury instructions need not specify the crime that the defendant intended to commit inside the burglarized premises. As an exception, that crime must be specified if it is material to the defendant's theory of case. Applying Bergeron,
Yep.
the Court of Appeals has held the jury instruction in a burglary case should not include the elements, even if the defendant has asserted a good faith claim. And then it goes on to say there is no statutory definition of what constitutes that crime. The Washington courts have construed the requirement with a, quote, common sense, end quote, view of the underlying purpose of the statutes to prohibit and punish conduct creating a risk of or actual harm to persons or property within a building. I have now provided that to defense counsel, again, multiple times. It is not required within the statute. It is not an additional element. The state has to prove at trial that the underlying crime has either in fact been committed or for the jury to elect which of those possibilities that they believe could happen or she was intending to go in, does not have to elect between those possibilities of behavior. So I do not think it is appropriate.
All right, and I also do have that instruction in front of me, and I thought I heard you say something different, Mr. Lair, which is why I had you repeat what you said. I'm going to use the instruction as proposed by the state. The WIPIC does not require, nor do these circumstances require that the court specifically indicate the language that was proposed by Mrs. Ali, that entering or remaining was with intent to commit the crime of violation of a court order, and I will not include that language. The instruction as was proposed by the state is a correct statement of the elements that need to be proven for the, that's the burden on the state. Number 47, any issue with 47, Ms. Stone?
It should have I think we have restraint provisions, language should be coming after provision of the order. Your Honor, can we come back to 47 and 48? We modified the language on that and we're going to resubmit that, so we'll provide those to the court.
Okay. All right. Actually, we're gonna start, it's noon, or it's a minute to noon. So we will come back and address the additional instructions. Mr. Kadine, since you are now offering an assault in the 4th degree as a lesser charge, I need you to provide over the lunch hour the elements as to that lesser charge. I already have the definition because the definition's already been previously provided, as well as a proposed verdict form, since you are proposing those instructions, and I don't have those.
And I do think Ms. So provided the initial request for those lesser included, that may be in the packet that she handed up to the court just a few minutes ago. So, and I think it went to both Mr. Leary and Mr. Kading as well. It's just the hard copy that Ms. So just provided.
I see.
The verdict form would not have been in there though.
All right.
So we need a verdict form for the less included assault or, right?
That's what you're offering, right?
Yes,
Okay.
okay, I'm just trying to make sure I got it.
I don't want to create instructions. I want to use the instructions that the parties have submitted. They may be changed, but the court does not want to create the instructions.
I know we're not talking about 151, but the only question I had at the outset, and I think we'll just need to flesh that out, is whether we had enough letters for lesser included based on the number of lesser included that we're going to be given.
Right, that's going to have to be modified based upon, I created the concluding instruction with one lesser included, because at the time I created that addition within that instruction, the only lesser crime was the assault in the 2nd degree.
And I do think you had indicated, Your Honor, to delete the special form. Do you think we need the special verdict form?
I added that language later on, which is, so look at the entire instruction. That's why I thought it should be deleted there, because it's included further down in the instruction.
Thank you, Your Honor.
All right, so we will be in recess until 1:30, and then we will take this back up. Mr. Leary?
I think there's one instruction left that I don't think is gonna be in disagreement, so I don't know if we wanna hammer it out now, or,
No.
I don't know.
I also need to look at the 2 WIPICs that I talked about under the burglary charge. And this also gives me an opportunity to hopefully make changes that we have discussed as well, in case I have any questions as I'm making those changes to ensure that I haven't missed anything. So the court will be in recess until 1:30. Thank you.
All rise, court's in recess.